Disclaimer. The comments made in this video are intended solely for entertainment purposes and are not intended to harm or offend anyone.
From a tenant's claims of unfair rent.
You're claiming that you overpaid them.
My rent was $2,120. Starting in January, they increased it to $4,081.
To a man repeatedly violating his probation and picking up new charges.
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever.
These three moments expose how Judge Simpson doesn't tolerate criminals outrageously and ensures accountability. Starting with Mr. Chain, who claims the increase in his rent was too much and unfair. And the crazy part is this man was given a condition that he refused to accept before that increase. And now he wants to be problematic about it.
Your name, sir?
Stephen Chattain.
All right. We're here on the money. Have the parties had an opportunity to try to talk to each other about it, or?
Judge, I've tried to talk to Mr. Chattain about this. He really didn't want to hear what I had to say. He said, I just want to let the judge decide.
Is that right, sir?
Mostly. He never has offered a settlement. He's never offered a settlement.
Okay. What's the primary part of your claim?
They nearly doubled my rent, saying I didn't meet the friendship requirement. As far as I've been able to tell, no such document exists. They have not produced it for me. They have not produced it for court. And because of that, I feel that they overcharged me for a year, saying that they couldn't find me a roommate and want to charge me for a 2-bedroom, 2-occupant for the full cost.
Okay. So let me just make sure. You moved out. You moved out.
I'm sorry, Lord.
Have you moved out yet?
I've made arrangements and we should be out by the 25th without any problem.
Okay. So you're claiming that you overpaid them.
Yes.
How much are you claiming you overpaid?
December of 2022, my rent was $2,120. Starting in January, they increased it to $4,081. That's $1,961 per month times 12 equals $23,530 in overcharge.
It's crazy how this man looks pissed, as if he wasn't aware of this in the first place, trying to make himself look like the victim. Watch and see how this man just chose to be problematic, making a big deal out of what he knew he should pay.
Can I ask a question then? Why'd you pay it?
It's a term, it's automatically charged to my account, and I have a conservator. That's where I got this report on monthly payments.
All right. So you have a conservator?
Yes.
You currently have a conservator?
Yes. Negotiating residency as we speak.
Okay. So let me ask you this. Did your conservator say anything to you about the amount of rent you're being charged?
Well, 3 months after the fact that they started charging me and called me and said, do you know that they doubled your rent? And I said, no, but I'll look into it. And he didn't feel it was right. And he wished me well in this negotiation that's about to happen.
Talk about a gifted liar who wants to manipulate things to favor himself. That is who we have here.
Do you have a position on his claim, other than you don't owe him anything?
Yes, and I'm happy to fill in a few of the gaps in the facts here, Judge. So Mr. Chattain's lease is a 30-day month-to-month lease. And it states in the lease that upon providing written notice, American House can change the rent. That's what they did here. They provided him written notice that they were increasing his rent. And the reason that they increased his rent, he's correct. His apartment is meant to be a shared unit with a roommate. And because of the condition of the apartment, they were not able to rent it to another tenant. They had given him warnings about this and saying, can't rent this to somebody else because of the condition of the apartment. Then they provided him with a notice and they said, if you don't get the apartment in condition where we can rent it to somebody else, we're going to raise your rent effective in January. That's what they did. They were contacted by the conservator after the rent went up, and they explained to the conservator, here's the situation. We've increased his rent because we can't rent the bedroom to somebody else. And the conservator said, okay. I understand. And didn't stop the ACH payments, continued to allow the money to be drawn. After about a year, Mr. Chatane got the apartment in the condition that American House decided it was satisfactory to try to rent it to somebody else. And they reduced his rent back to the original amount.
Because they were able to rent.
They still weren't able to rent the room to somebody else, but they had asked him in writing, we want you to do A, B, C, and D to get the apartment in a condition where we believe we would be able to rent it. Because of other issues, they were not still able to rent the apartment to him, but they followed through with their side of the agreement and reduced his rent. Yeah.
Is that correct?
No,
Okay. Of course not. So what part of that's not the case?
it was not a question of them increasing the rent as in a normal annual increase in rent. They changed the terms of the contract from me living in a 2-bedroom, 2-occupant suite to saying you're now renting the whole
Mr.
suite.
Chatane, yes, but that was their claim, wasn't it?
Well, they never provided
Well,
me.
hold on,
I'm
hold
sorry.
on. That was their claim. It was supposed to be a 2-occupant suite.
At this point, Judge Simpson is already fed up with his unreasonable argument. I mean, this man was given conditions that he completely ignored.
Right.
Okay.
I had 4 roommates before this over the last 10 years, and they've all complimented me on how nice it looks. It boiled down, in my opinion, it boiled down to the question that I had masks from all over the world on the walls, and I had a very demure nude, and none of my roommates
Severe what?
nude, N-U-D, naked woman.
Okay, I'm presuming,
Yes, and they
presuming a statue.
I'm sorry.
Was it a statue of a nude woman or
No,
actual
just a
nude
painting,
woman?
Just a painting.
Okay, all right, thank you.
Whoa, now that's crazy. Did he just say nude like a woman's naked painting? I bet Judge Simpson is trying to hold back his laughter now.
Go ahead.
Well, they demanded more room, and they made me throw away my leather sleeper sofa because they wanted more room in the room. No one had ever complained about this.
Mr. Chatane,
Yes,
you would agree that there was supposed to be another occupant in the room?
absolutely. They
Okay.
will admit that I asked for a roommate.
Okay,
continuously.
but hold on. They then did they send you information saying they couldn't lease the other room?
No,
So they never sent you anything?
I have included everything.
I didn't ask you what you included. Did they send you some notification regarding what you needed to do so they could rent the other portion?
No,
Never.
nothing. After
So-
repeated requests.
So if I set this for trial and they have that, you might admit that you don't have a claim.
Of course, but they've never provided it in the last 2 years.
Okay, so
It doesn't exist.
at some point, Mr. Chatane, your rent goes back down,
Right,
right? So why did it go back down?
because I threatened to sue them for their mistreatment.
So they just lowered your rent.
Well, they made me do a number of things because they were going to already increase rent another 10%.
So what were those things they were asking you to do?
They made me remove most of the artwork from the living space. They made me clean off my own dining room table where I had a sculpture. They made me throw out my couch.
But hold on, this dining room table. The dining room table would have been shared by the dining room area would have been shared by the occupant.
Everything that's in the apartment is shared.
So they asked,
Silverware, you name it.
okay, so they asked you to remove
All the stuff that was on the
the dining room table so that if there was somebody else there, they could use the dining room table.
And the prior
Exactly.
roommate did use it instead of going down to the dining room.
Okay. So what else did they ask you to do?
Now he is selling himself out, not even realizing it.
They asked me to remove half of the material in the linen closet, which was easily done. They made me move.
So that the other tenant, if they were there, could have space.
Right.
Okay,
They made me remove half of the material that was in the shared closet. It had never been a problem before. It had accumulated for 12 years, 10 years back then. And I was able to do it, but I gave away, I would guess, thousands
Mr.
of dollars
Chastain,
worth of stuff.
Chastain,
Yes,
have you listened to what you've said to me?
you asked me to go on.
No, I know, but have you listened to what you've been telling?
They out of the blue produced
Mr.
an
Chastain,
article that
Mr.
said,
Chastain, Mr. Chastain.
yes,
How did you get notification that they needed you to do these things?
I never got notification without asking for something in writing that shows that these friendship suites exist and what the requirements are. They gave me a list of things that were particular to my room, and it's not a general policy.
Mr. Chastain.
Yes, I'm sorry, if
How-
I speak loud, it's because I've got these.
I understand. How did you know what to do?
After corporate officers came out and said, this isn't a friendship suite, and I asked why, and they said it looks lived in. That's all they
So
said.
let me ask you this. When they talked about, let's say, the dining room table.
Yeah.
Did they tell you why you needed to clean off the dining room table?
Well, half the table was covered with my current mail, and they wanted everything off the table.
Mr. Chastain,
I'm sorry.
you need to answer my question. Did they tell you why you needed to clean off the table?
In case my roommate wanted to eat,
Yeah,
and I did.
okay. But before that wasn't the case, right?
Not after my last roommate left. I told you.
Okay,
I made
all right. So let me ask you this.
All right,
Did they tell you why they wanted you to empty out half of the closet?
because it belongs to the other person, my potential roommate, and that was very
So,
difficult
Mr.
to do.
Chastain,
Yes,
if you're paying, let's say 2120 for a space that would, if the landlord could use it, would cover twice that amount, right?
I didn't quite catch that.
They had another person in there, presumably that person would be paying the same thing that you pay,
Yes.
right?
Yes.
Okay. So, Mr. Chastain, if you're using the whole thing,
I'm not.
if you're using the whole thing, then don't you have to pay for that?
But I'm not using.
But they didn't ask you that. If you were, let's put it this way, listen to my question.
All right.
If you were using the whole thing, you would agree, we could all agree that you would have to pay for it.
That is it. The fact that this man is using an apartment meant for 2 people and still has the nerve to complain about his payment for it is outrageous.
Right?
Yes, but I'd have.
If you're using it to the extent that they can't move somebody else in, you would be required to pay that, wouldn't you?
Yes.
Okay, I'm going to tell you, as I'm looking at this, that's what happened. Follow me, Mr. Chastain. Here's what the deal is. You're using the whole unit, basically.
They're saying.
Whether you're admitting that you did, because you're admitting that when they notified you, you basically started putting it back in shape so they could put somebody else in it. You're using that property. And so if you're using it, Mr. Chastain, you have to pay for it.
They wouldn't tell me what I had to remove.
Judge Simpson at this point is gradually losing his patience. I mean, this man's outrageous behavior is enough to make anyone crazy.
I asked for 9 months as soon as it started happening, and they refused to give me something. I talked to corporate. They said it looked lived in. They finally gave me a list in October and said it had to be done by.
But I thought they didn't give you anything.
After I requested it and after corporate came and announced that it was not a fridge, they did produce after, I believe, 10 months. So they were.
So before then, Mr. Chastain,
Yes,
before then, you were just paying this amount of rent, right?
I was paying.
And had no idea why you were paying.
I don't quite understand what you're driving at. Could you give me a little bit more so I can
You
respond?
were paying twice what you had before, but had no idea why.
No, everybody that lived with me thought it was
I didn't care about everybody else living with
Uh,
you. Your rent doubles.
Yes,
Your conservator knows,
Yes.
right?
yes.
Your conservator tells you, right?
He tells me when the increase went up.
Okay.
That's all he told me.
And you're saying you paid it and didn't know why?
That is correct. It was because I wasn't meeting the requirements of a friendship suite, and they have never
Hey,
provided the
Hey, that's
requirements for a friendship suite.
Mr. Chastain. Let's get off of that phrase friendship suite.
Well, it's key to this because.
No, it's not.
All right.
Because what's key to it, I don't care what you call it. What's key to it is there's supposed to be somebody else there.
Yes.
And there can't be because you are using the other part of the apartment.
A tiny part, nothing in its bedroom or anything.
But you're using it to the extent that they can't put somebody else in, Mr. Chastain.
Well, that's not true because I've had 4 roommates and nothing has changed.
Does he even expect anyone to believe him? This man just wants to avoid taking responsibility, so he's just lying foolishly and exposing himself.
Judge, this is the letter that Mr. Chastain attached to his own pleadings. It's dated November 30th, 2022. And
Which exhibit?
it's Exhibit I to his own pleadings. Maybe it's
You said it's November 30th.
November 30th, 2022.
Got it.
It says, Dear Steve, as you know, you currently reside in a friendship suite. We have had conversations in the past asking you to clean out the apartment in order for someone else to be able to move in. At this time, we feel that we can no longer offer this as a friendship suite or even be able to show to prospective residents due to the smoke odor, lack of space, and condition of the apartment inside and outside. All of the above are considered lease violations. Then it goes on to indicate how they're going to raise his rent, and they give him until basically the end of December to try to get this resolved. Starting January 1st, his rent's going to go up. So they put him on notice of this, and he attached it to, so obviously he had a copy of it because he attached it to his own pleadings.
See it?
Well, from my point of view, they're making a lot of claims. There aren't.
Mr.
I see the letter here.
Okay, and Mr. Chastain, you would agree with me?
No,
That-
not at all. The
Okay.
smoke odor, lack of space, and condition of the apartment inside and out is utterly false.
Why'd you?
And they took my apartment.
Mr. Chastain,
Yes.
you told me they never sent you anything.
With regard to why I'm not meeting a friendship suite.
Mr. Chastain, what does that letter say? Doesn't it tell, doesn't it?
I'm sorry. I didn't-
That was a question. What does that say?
I don't really know how to respond. You know,
Well, you're gonna,
I've lived
you're
here 10
going, you're
years.
going to need to respond to my question.
all right.
What does that letter say to you?
It says, my apartment doesn't meet the requirements of friendship suite, and therefore we're doubling your rent. That's what it says.
And it tells you why.
These, if you look at these,
Mr. Chastain,
smoke over.
Mr. Chastain,
I don't smoke.
it tells you why, doesn't it?
The fact that this man just doesn't want to respect himself and give up these lies and arguments is alarming.
They never gave me anything in 9 months requesting what I need to do for a friendship suite. These 3 things, you know, that's their opinion. Fine. Show me the friendship suite requirements. And they didn't have any. They don't have any now. They made up this list particular to me. It's not a policy and it's not in my lease.
Now Judge Simpson is fed up. Is it that this man doesn't understand, or he doesn't want to understand that his claims are baseless?
Judge, what I would say is that it's not relevant whether or not any of that stuff is in his lease. What is in his lease is that they have the right to increase his rent with 30 days notice, and they gave him the notice.
Yeah, you realize that, Mr. Chastain.
Well, they increased it. I know that. For 9 months, they didn't tell me why. These are not reasons.
But hold on, Mr. Chastain. Understand something. They could have increased your rent and not given you any reason why.
I'm sorry?
They could have increased your rent and not given you any reason. On 30 days notice, they could increase your rent. They don't even have to tell you why they're doing it.
Well, that would wind up in court too, then I guess.
And you'd lose.
I'm sorry.
And you would lose.
That's why we're here.
Yeah. So you can lose.
No,
Oh.
to settle the matter. If you say I have no claim, fine. I'll
Well,
stop here.
I'm going to tell you, I don't see where you have a claim. You're telling me things that aren't true. You're telling me they didn't send you anything saying what they were doing. Do not interrupt me. You told me that. You told me that you did not know.
That I was in a friendship suite. I did not know. I in the letter I sent to you, I said, I never heard of it before. Nobody I talked to ever heard about this. If it had been in the lease or if they sent me the requirements, look at what they asked me to do compared to these three vague things they listed in this letter. Look at them. They're specific things. You can't have your toothbrush and toothpaste on the sink. They just made up a bunch of stuff. Ask them to produce the document that says what a friendship suite is.
Mr. Chastain, why do you have a conservator?
Now that's the point. Why is he here alone?
I had some mental issues in the past, 10 years ago, 12 years ago. And at that time, I was not capable of paying my bills. So the conservators worked out. It's not horribly expensive. And he, just like American House takes care of all my needs but a telephone, my conservator took care of all of my needs. So, I don't have any problem having a conservator.
That conservatorship is still pending.
I'm sorry?
The conservatorship is still pending through the court.
No. I've had the conservator court approved 12 years ago when I first moved into American House.
Through Washtenaw County.
I'm sorry?
Was it through Washtenaw County that the conservator was appointed?
Yes.
Who initiated the petition for appointment of the conservator? Do you know?
I talked to the manager then, and then my conservator took care of the paperwork. I signed the lease back then.
No. I'm talking about the case where you had a conservator appointed.
Yes.
Who initiated that case?
Well, I asked the court to appoint a conservator for me.
So you started it?
I believe so. I don't know who else would have. That was a long time ago.
And I'm just going to tell you this because have you talked to your conservator about this?
Yeah.
Okay, let me ask you this. You don't manage your financial affairs.
No.
And so did you tell your conservator that you were filing a claim that might affect your financial position?
Might affect it? How so? He knows I'm here. He asked if he should be present.
And what did you tell them?
I thought we were going into your chambers and I told him I didn't think it was necessary.
Oh, I think it's absolutely necessary.
Can I ask why?
Because you don't manage your own financial affairs and you filed a suit for money damages.
I'm not a stupid man.
I never said that.
He is not a stupid man, but what do we say about his claims, attitude, and lies? They say otherwise.
I suffered for a year because they wouldn't tell me what I needed to
Mr.
do.
Chastain, I'm not calling you stupid. I'm not saying anything about that. I'm just pointing out the fact that you do not manage your own financial affairs.
Correct.
And there is an individual that does manage your financial affairs. What you have filed here has an impact on your financial affairs. And so your conservator should be involved.
Well, he told me just yesterday that if I were to prevail, that the amount should be made out to me with Jim Baker as a conservator.
I know. What happens if they file a claim and you end up owing money?
I asked the court to talk to my conservator. He takes care of my financial affairs.
Said you had a conservator for 12 years?
Yes.
And he knows that you filed a counterclaim.
Yes.
Did your conservator say anything about maybe you having an attorney?
No.
16.
16.
Monday, 16.
No, that's fine. That will work. I think they have to file. It can be signed and executed. 16.
Yes.
Mr. Chastain, have you thought about getting an attorney?
No.
Okay. I think that you might want to take a look at it.
If you turn me down,
No.
stop. I don't see any reason to spend more money on this issue. If they think that they didn't lie by saying I didn't meet the requirements of this word I'm not supposed to use, where's document? That's all I ever asked for, so I can comply with it. And as it got down to the end of the year, they started making demands and they were going to increase my rate even more. So I worked very hard for 2 months to meet their requirements. That isn't a policy. It was specific to my place. And that's not a policy. They say they could have said, we reserve the right that you meet these, and everything would have been fine. It never would have arisen. I have no more furniture in my apartment now than I did when I moved in 12 years ago. And I've had 4 roommates. How can they say that I don't have enough space? Anytime any of them ask.
Mr. Shate,
Yes.
you told me that the apartment was supposed to have another person.
Yes.
You've also told me that you had things in there that would prevent another person from having basically half of that unit. Why you had it, I'm not even worried about that. It doesn't matter to me. They could not put another person in. They then sent you information of what they saw as lease violations and further informed you that they were going to raise your rent.
Yes.
You may not like it, but I don't see anything that they've done that's wrong.
It seems to me that if they claim that I don't read requirements and they have no requirements on writing, I don't see how that's legal. I have a real problem with that.
Okay, so this is the final settlement conference. You want me to set it for trial, but I'm going to advise you of something before you answer that. They can ask the court to impose sanctions for the filing of a frivolous claim.
If you say so, I don't consider this frivolous. I've got the documentation right here.
The audacity for him to still claim this is not a frivolous case after wasting the court time is annoying. I mean, this man just wants to shift the blame and avoid taking responsibility.
Okay,
Yes.
I'm going to advise you that they could ask me to do that and to basically impose sanctions for their attorney's time and for everything else. I would also tell you that I don't see, based upon listening to you, based upon looking at the documentation, that you have a colorable claim in this case. But if what you want me to do, if you want me to set it for trial, I will set it for trial.
I was hoping, and I was under the understanding that I asked for a summary judgment in this matter, so it would end now. Either I win, lose, or you demand that we have arbitration. And that's fine with me. I don't want to spend any more time with this. I think I've been wrong. They've treated me.
And what I would suggest, because they haven't made a money claim against you, what I would suggest, Mr. Shate, is that you might want to consider dismissing this case against them.
If that's your advice, I'll.
No, yeah, you know what, Mr. Shate, you don't have to. I'm going to make that suggestion to you. I'm telling you, I don't see anything that gives you a colorable claim.
Like you just drop the case.
You want me to dismiss the case?
Yes.
The counterclaim. Any objection?
I have no objection to the counterclaim being dismissed.
Counterclaim is dismissed. I'm going to do that with prejudice as to the counterclaim. Mr. Shate, the only thing that I would issue, because the possession issue, they can issue a writ to have you removed. You're going to be out by the 25th, you think?
Absolutely.
Okay, very good.
Judge, do you need me to file anything with the court with regards to the dismissal of the counterclaim, or the court handle that?
Would you just prepare an order, and maybe you could find a handwritten one that just says defendant is dismissing his counterclaim?
Okay,
That's
you would need to
something that-
design that then?
If you get it to me right now, I can just sign off on it.
I don't have a form for that.
You pull up a general dismissal form, or is there one out at the clerk's office? We'll get a form, counsel.
Okay.
All right, thank you.
Thank you.
Mr. Shate, Mr. Shate, come here.
Yes, sir.
As you've been treated with respect in this courtroom,
Yes,
and I haven't allowed anybody to say anything to you,
okay,
you will not walk out and address anybody in this courtroom that may be associated with the plaintiff in that fashion that I just heard.
fair enough.
I want you to turn around and I want you to apologize.
I apologize.
You may remove the headset and you may leave quietly.
Thank you, Judge.
Thank you.
I must admit, Judge Simpson's patience in this case is unmatched. I'm impressed with how he just handled this.
Why are all these other people here? I'm done. I'm going to the Bahamas. Goodbye.
Unlike Mr. Chain's case, this one centers on a father fighting to protect their son against his ex Alyssa, who is now seeking to lift a no-contact order against her, despite violating it and now claiming ignorance of its existence.
Couchman, please state your name.
Maurice Couchman.
Teresa Claire on behalf of probation. Your Honor, it's my understanding that the victim in this case, Alyssa Chamberlain, should be present via Zoom.
Alyssa Chamberlain?
Yeah, I'm here.
Okay. Yes, she's here.
So, Your Honor, it's my understanding that Ms. Chamberlain would like to address the court to request the court lifting the contact order. Does the court want to address that first, or my recommendation for Mr. Couchman?
Either way, go ahead with you.
Okay. So as to Mr. Couchman's recommendation, he is compliant with the terms ordered by the court. I did make his appearance, however, he is present today. Probation is recommending that all conditions continue as previously ordered, with the next review hearing being set February 10th, 2025 at 1 p.m.
Sir, anything you want to say?
I know she wants to take the order away or whatever. I want to keep it.
Okay, so hold on. Ms. Chamberlain?
Yes, sir.
All right, do you have a camera?
Yeah, you want me to turn it on?
Yes.
Okay. Hello.
Hello.
Hi.
All right. What did you want to tell me?
I just wanted it lifted because I've been in contact with his mom to see our son Leo, and she hasn't really been compliant with it.
You've
the
been in
last-
contact with whom?
With Maurice's mom.
Okay.
And she hasn't really stuck to her things or anything like that. The last time I was supposed to pick Leo up, she completely ghosted me. So I was just hoping to maybe lift the no contact order to just talk to Maurice directly, but just about our son.
Now this leaves me questioning the crime she committed to make this man stand his ground.
Okay. And thank you. And you have a problem with that?
Yes, sir. Yes,
All
sir.
right. Hang on before you go.
People would be opposed to any change in the no contact order at this time.
All right.
It's my understanding from probation that, probation, I don't know if you're taking a position or not, but people would be opposed to it.
All right. Sir, what did you want to tell me?
I just want to keep it like it is, no contact.
You want to keep the no contact in place?
Yes, Your Honor, because I don't know if you were been told, but there was an incident a couple weeks ago. Her and her mother came to my house, and basically how I have it set up is my mom is supposed to make contact with her, and the last time she tried to make contact, she said she was going to pick the kid up at 4. She never picked my son up. She just ignored my mom. Alyssa
Okay.
Chamberlain.
Okay.
So,
go ahead.
she came to my house.
Who did? When you
Alyssa
keep
Chamberlain.
saying she,
I'm sorry,
I'm just
I'm
trying.
sorry.
It's okay.
Alyssa Chamberlain is just
Right.
nerve-wracking. Alyssa Chamberlain came to my house with her mother with the no contact. She's not supposed to be around me. I told her that. I called the police and made a police report. There's no reason for her to talk.
Okay. So hold on a second.
The fact that she didn't just violate the order but also neglected their child and is now asking for the no contact order to be lifted is crazy. Would you risk doing that for someone with this attitude?
So, because I just want to make sure I understand. The arrangement was set up that your mother would act as a go-between, basically.
Yes,
Is that right?
yes.
Okay. And then for whatever reason, something happened where you're claiming Ms. Chamberlain did not get the child from your mother. Is that right?
Yep.
And then 2 weeks ago, you're saying thereabouts,
Yeah.
that Miss Chamberlain and her mother
Yes.
show up at your house
Yes, Your Honor.
and that you ended up calling the police.
Yes, Your Honor.
Ms. Chamberlain, is all of that correct?
So kind of, it was me and my aunt, and we did show up at his mom's house. But at this point, I didn't know that me and Maurice had a no contact order. I wasn't aware of any of this. I moved and didn't receive any paperwork. I changed my number, so I wasn't receiving any calls or anything. So what happened
What do you
was
mean? What do you mean that you didn't know?
I didn't know there was a no contact order.
Now she's lying in court. Does she even think she can fool the judge? That's too much.
So
I didn't even know Maurice got in trouble.
Hold on. So why do you think you were why was his mother then acting as a go-between?
I just thought he didn't want to talk to me.
Okay, so it sounds like he still doesn't want to.
That's okay, but we need to figure something out to where his mom answers the phone and sticks to her stuff when I'm supposed to pick our son up.
Okay, so I'm going to assume that his mom,
Yes, sir.
I take care of.
hold on, that she's a full-grown woman, and so are you, right?
Yes.
So it seems like for your son, her grandchild, that the two of you could talk to try to work out whatever you guys want to work, and that Maurice doesn't necessarily have to be a part of that, does he?
I mean, no, and it wasn't a problem until the last time when I was trying to get Leo. She told me I could get him, and I confirmed it the day before and then completely ignored me. So then that's when me and my aunt went to her house to try to talk to her.
Don't be surprised if she just didn't want to cooperate with his mom, and she is looking for an excuse just to talk to him.
I didn't know Maurice
Right.
lived there.
Okay. So here's what I'm going to do, because there's obviously something else. I'm not entirely clear what's going on, but if he got into a circumstance where he had to call the police, then that circumstance can't happen. So I don't know what is going on, and you guys as parents need to figure this out for your son, quite frankly. But as between the two of you, if he doesn't want to have contact, I'm not going to force him to have contact. I mean, he's relying upon the court's order, and he did, quite frankly, given the other hearing I had today, he did exactly what he was supposed to do when you showed up. He wasn't trying to do anything. He called the police because he's the one under the jurisdiction of the court. But if he doesn't want that, I'm not going to change anything.
With this pretense and attitude, I'm sure she's the problem here. What's so hard about communicating with the grandma for their son if he doesn't want to see her anymore?
Okay.
And for the record, Your Honor, I asked probation if there was currently a circuit court order regarding parenting, and there is not. And the defendant has custody of the child this time.
Who does?
The defendant.
You have custody.
Yes.
I do not have
Hold
legal
on.
custody, but I've been taking care of my son for the last 8 months, taking him back and forth to school, everything.
Okay.
So.
I'm
now
just
you're
being-
giving-
No, I got you.
Now you're giving legal advice about what to do, but.
Well,
There's no-
somebody's gonna have to figure, you guys are gonna have to figure something else out. But, ma'am, Mr. Couchman does not want contact with you directly. So I'm not gonna place him in a position where he has to do that, because obviously he's maybe through this process learned something. So, I'm just gonna leave everything where it is. I'll continue all of your, Mr. Couchman, I'll continue all of your previous terms as ordered. I'll set your next review hearing for February 10th, 2025 at 1.
As expected, Judge Simpson, seeing through her, denied the request.
Thank you.
Okay, thank you.
This case here is focused on Mr. Carter violating his probation and going on to recklessly pick up new charges. This man will leave you questioning his audacity to behave so toxic.
David Burgess on behalf of Mr. Carter.
Mal Carter, thank you.
Teresa Clare on behalf of probation. Your Honor, Mr. Carter is before the court for an adjourned violation of Mr. Carter. When he was last before the court, did have a pending felony case. The court did arraign him on that bench warrant. He was set for court. That case that is pending is now set for appeal on November 5th. Mr. Carter now has another new pending case. Domestic violence second offense, and it interfered with communications with an alleged date of offense of October 20th, 2024. He is on bench warrant status in that case. Given that there has been continued alleged assaultive behavior with the added victim in this case, because the court did add a no contact with that victim, it does make it a violation of this case. Probation's asking that the court, one, address the felony warrant on that 2-4-FB case. If the court does have it, that the court revoke probation and sentence Mr. Carter to jail 365 days, credit for 162 days served to serve the balance, that he complete the jail DV program, waive remaining terms, accepting his financial obligations, and discharge him from probation.
Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case. So
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know if you're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already. So.
It's a charge of interfering with electronic communication device, the 2-year felony. And then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor, as it relates to both those charges, waive any further reading of the warrant, stand mute to both those charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. And Your Honor, he just got a new job. He was unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honors, indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
The fact that this man refused to learn from his mistakes after his probation and still went out misbehaving is outrageous.
Anything from the people.
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they had contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back, represented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope of probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time.
Full trust in Judge Simpson. He wouldn't let this man go free.
And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring.
He knew there was a no contact order, yet he still made contact with the victim left to me. He deserves nothing but jail time.
Less than 2 weeks later, and tried to give you every benefit. And I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything, because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't, but
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever.
Using a shitty excuse like this doesn't even make sense. Judge Simpson isn't buying that. No one would fall for that.
I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go. You can say whatever you want.
She put up on me. I was in the room playing my game, and she came in the room. And
then you get up and leave.
Tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr. Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you got another case.
Now he must be silly to think he'll be going free this time.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I post sentence on that case?
I want to say I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm be by myself.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocate, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
Perfect shutting down for a criminal who thinks he can just blame others for his outrageous behavior.
Then I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm going to revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served, defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. I think they just requested DV. The court want the defendant to perform both or just one or the other.
I should have said in jail DV program
Thank you.
is what I meant to say.
Thank you.
Thank you. Defendant's remanded.
Okay.